What is the status, please?
Judge, we've asked Attorney Navreski to join in this hearing this afternoon to make further argument.
Thank you, Your Honor.
So wait, now, are we relitigating the motion I already ruled on?
Yes.
And is there something new that I haven't already considered?
Yes, we believe so. Attorney Navreski will address the issues that we don't think this court considered.
All right. Go ahead, Attorney Navreski.
So the state denied the request of the parties for pleading counts 3 and 6, based primarily on finding that it was not in the public's best interest. There's kind of two things about Kenyon that I believe haven't been addressed by the court. First, Kenyon is can you hear me okay?
I can.
I would like him to speak
Oh,
louder.
could you please speak up a little bit for the court reporter? Thank you.
So Kenyon was based on a kind of very different procedural perspective, where the state wanted to dismiss a case to refile as a felony, and the court, acting under 970.03, said, no, I think this is more appropriately a misdemeanor, and refused the amendment and the dismissal.
Sure.
And second,
But that's, I mean, Kenyon was cited at great length in Conger, which is far more applicable factually to what we're talking about here. That's Conger is 2010 WI 56.
Kenyon also speaks to another aspect of the public interest that the court needs to take into consideration, and that is that the prosecutor is given sufficient freedom to exercise legitimate discretion and to employ the best effect his or her experience and training can make, and essentially fulfill that statutorily and constitutionally independent role of deciding which cases get prosecuted, which charges are brought, and the strength of their cases as they go to trial. This case has been heavily litigated. Trial prep has been underway. We are not privy to the state's trial prep, what reasons they have for moving in the direction they have on fee negotiations, resulting in the given offer. That's not for us to know. The state has its own ability to exercise that executive authority with some limits placed by the court and the court's inherent authority.
I'm sorry, I didn't hear his last.
Well, you'll need to repeat what you just said, please.
The ability of the state as the prosecutor to exercise its constitutional function independently, there is room for the court to act in its inherent authority to consider the public interest. That needs to include the public interest focus of the state being able to act without undue influence by the judiciary in its charging and prosecutorial decisions, and in determining its own readiness for trial and what appropriate concessions are going to be made if its readiness for trial is, for whatever reason, in question, or it just does not feel that certain aspects of the case are likely to be proved. So here, the state has come to us with a plea agreement. We brought it before the court. It is a count that has already been charged. It's already been prelimed. Mr. Hauschultz would like to enter his guilty plea as to that count, with the rest dismissed and read in. And the prosecution, the state agrees that that is a just result. And the court is saying no, simply because of objections of a victim and general feelings that it is not a strict enough punishment. The other problem with that is the court seems to be predisposed to how this case should play out or should resolve. If the court is saying this punishment, this set of charges, is not severe enough for the court's liking, you are suggesting that you believe after trial additional counts will be convicted, whereas that's obviously inappropriate for a judge to comment on for a trial, and it's certainly not assured in this case, where there are 8 different counts, any or all of which could be not guilty. This is a fair middle ground between the risks of going to trial for the state and losing, and the risks of going to trial and losing for Mr. Hauschultz. And so we would ask the court to reconsider, especially based on the independent exercise of prosecutorial discretion by the state, that I think the court has not taken into consideration in its ruling so far.
Thank you. I think the parties, I'm sure, are very well aware that the district attorney's absolutely pretty much unfettered discretion in deciding what charges to bring, and whether to bring charges at all is well recognized. They are vested with a great deal of authority by the legislature. They are constitutional officers. But once a case is under the jurisdiction of the court also has independent discretion that it has an obligation to exercise. If the court is only here to rubber stamp agreements, then what is the point of an independent judiciary? That flies in the face of our system of checks and balances that is inherent in our system of jurisprudence. So I do reject that argument. This is also extremely clear in the cases, including going back to 1935 with Geither, which I believe is Guither versus Milwaukee at 217 Wis 334. The court's authority is invoked once a criminal complaint is filed. The DA absolutely has a great deal of discretion in what to take to trial, what plea agreements to reach, whether to dismiss, whether to enter into plea agreements. But it's not unfettered authority at that point. The argument that I've already decided what a sentence should be is also misplaced. I have no idea what the sentencing arguments would be. I have no idea what the parties would say. I don't even know what the recommendations are as to sentencing. I have no idea what I would ultimately impose if I accepted this plea agreement or if one charge was convicted at jury trial. I don't know what a jury would do. There's always a risk that there could be an acquittal and we won't even get to sentencing. That is the risk of our system of a jury by our peers. And that's a risk the state takes and the defense takes in determining whether to go to trial. That doesn't mean that I am bound by a plea agreement. And the case law is very clear on that point. Did you want to be heard again, sir?
Yes, there is another case that I want to point the court to that is one of the most recent Court of Appeals decisions that kind of addresses this issue. It is not published. It was a one-judge decision. That's State versus Rivera.
So it's not even citable as persuasive because it's a one-judge decision?
It certainly can tell you the flavor of the Court of Appeals' take on these issues. It's a District 2 decision.
I don't know what point you're going to make with a one judge. So one Court of Appeals judge has an opinion. What I'm bound by are these binding Supreme Court precedents.
Well, I guess this is the state's argument. I haven't had to make it before in the role of a prosecutor. The court can't prevent the state from simply not putting on a presentation as to the counts that the state does not want to convict on.
Absolutely, and the state can move to dismiss charges they don't want to proceed to trial on. The state does still have the ability to react. I don't have to accept a plea agreement. And I've previously ruled that I'm not going to accept this plea agreement. I gave the parties half an hour to negotiate. I didn't give the parties half an hour to come up with new arguments. I've made my ruling. I need to know how the parties want to proceed. Are we going to start trial on Monday, or are you going to continue to negotiate?
Well, we've reached an agreement, Judge. You're telling us you're not going to accept it.
Right?
Are you telling us today the court would allow the state to dismiss if they choose to not proceed to trial on counts 1, 2, 4, and 5?
That's not what I'm saying. That's not what's before me. I'm saying that if the state makes a record that they don't feel that they can proceed on a charge, then make that record. That's not what's here. That is not what I'm being told. I'm told that in trial preparation, the state has determined that this is a fair plea agreement, and the defense agrees. I do not accept this plea agreement. So are we going to have a trial on Monday, or are you going to continue to negotiate?
Well, I think that we need to hear from the state as to whether they want to dismiss counts 1, 2, 4, and 5. And then,
And then we can have a trial on the other charges? Is that what you're suggesting?
the other 2 charges Mr. Hauschultz can plead guilty to.
I'm not accepting this plea agreement.
You want him to go to trial on the only 2 remaining?
I want you to determine what you're going to do in light of this ruling.
Well, since we've spent the last 2 days negotiating and doing other things, we'd ask for a delay on the start of the trial.
We can start on Tuesday morning. We can have the motions that were going to be heard right now, we can hear them on Monday.
The court still didn't issue its rulings on the certain issues like the social worker testimony.
Right, that's what we were going to do today, if you will recall, and you said that we were going to enter a plea. We're not doing that now, I'll rule on them on Monday. We'll have a motion hearing, we can start at 10 o'clock.
The clerk indicated in a note that you were going to rule on the social worker.
And then I was told there was a plea agreement. As I told you in November, I've been in jury trial for the last 2 weeks, and we didn't have time for another motion hearing. We can do it on Monday, they'll start trial on Tuesday. And we are adjourned for now.